Good evening or morning or whenever it is. Not legal advice. Like, subscribe, share. Tonight, I wanted to do a short video on Tesla and a court ruling that might impact their business that came out today. But before that, of course, like, subscribe, share, let your dogs watch, etc. But before we start, I wanted to get a couple things across. What's the difference between a poorly dressed man on a bicycle and a nicely dressed man on a tricycle? Of course, a tire. And last but not least, acupuncture is a jab well done. Anyway, getting to the real subject matter of this particular video. So Tesla was involved in a trial in Riverside, California. Riverside is a county in the southern part of California, slightly southeast, and in Southern California. It's considered to be a more conservative part of Southern California. I don't think that Tesla products are as prevalent as they are closer to the coast of California, but they may be, and they may have certain likings or dislikings of Elon, but we don't know about that. But it's not Los Angeles, for example. And so we don't know if their acceptance of Tesla is greater or lesser, but be that as it may. The basic facts of the lawsuit were that in 2019, a gentleman by the name of Michael Lee was driving a Model 3. Suddenly, he was driving at 65 miles an hour and he veered to the left, ran into a tree, car burst into flames. He was killed. Two passengers were badly injured. So this occurred, I believe the accident occurred in 2019. 2020, I believe June of 2020, they initiated a civil action in Riverside County because that's where the accident happened. And they claim that there was a manufacturing defect in the autopilot system. And it wasn't the driver who caused the accident, it was the manufacturing error that caused the car to abruptly go left into the tree and harm everybody in the car. So the driver unfortunately perished in the accident, and the other two remaining injured victims sued Tesla and the estate of the deceased driver. And they sought approximately $400 million for damages, which is probably a ridiculous amount of money, notwithstanding whatever the injuries were, but it's probably an excessive demand. So that was the basic claim, and Tesla was defense to the claim of the manufacturing defect, and they would have put on expert testimony showing that there wasn't a manufacturing defect in this particular case. But Tesla's defense was that the driver was at fault, that he wasn't careful enough, and in fact had been drinking prior to the time he entered the vehicle. I don't think there was a conclusion that he was under the influence, but I think there was certainly a conclusion that he had been drinking. So the case went to a jury in Riverside, and the jury was a 12-person jury. And in California, in a civil case, this was a civil case, a jury has to be made up of 12 members unless the parties agreed to use less. In this case, obviously, they didn't agree to use less. And no matter what the number that is agreed upon, there has to be at least 75% of the jurors who vote one way or the other to get a unanimous verdict. I know unanimous sounds funny, but to get a verdict that will withstand, that will be sufficient. And in this case, the final breakdown was 9-3. So 75% of the jurors voted in favor of Tesla. Now, you have to remember, as I said, the driver who was deceased and his estate were also defendants. So during the trial, next to Tesla's uh, seat, because they're a defendant, and so you have two tables or three tables. The defendants would be on one side, the plaintiff, the injured parties would be on the other side with their counsel. And oftentimes, when there is, in essence, Michael Lee, the deceased driver, is not there. So when a defendant like that is not there, often the other defendant can use them as a defense. And that's what they did here too. So they would have pointed to the empty chair, and in essence, they would say it's his fault, along with the case establishing the facts that there was not a manufacturing defect with based upon expert testimony and otherwise. You have to take into account that California is a very consumer-oriented state with a lot of litigation. So plaintiffs do very well generally in California. So in this case, because of the positive result for the defendant, Tesla, in this case, it may be a preview of future results in other locations outside of California in similar cases involving autopilot or full self-driving or any other means. So it may be a preview. However, it's not really precedent. So I know I hear people talk about what a case is, and they'll talk about a result and they'll say it's precedent. So I want to kind of like explain how I think of precedent and how I think of this. So precedent to me is a decision by a judge or court that is binding upon other courts or other parties in other cases. So generally, that would come from an appellate court. So you'd have a lower court like this, have a trial, and then you would have an appellate court review the case and issue a ruling either confirming or reversing the ruling. And now that would be precedent. It would be precedent in the area that it was that it occurred. It may have greater precedential value, but it really requires an appellate court. So a court that's reviewing the trial court's decision to make precedent. So here we have just a trial court's decision. And even though it went in Tesla's favor, it was 9-3. So it wasn't like it was no problem. And it also took 4 days of deliberation. So I would speculate that it took them a while to get to 75%. So it probably wasn't until when they actually reached the last verdict, because what'll happen often in jury rooms is the jurors between themselves will take polls and they'll take informal or formal votes. And so it may have been 8-4, and then through pressure or discussion, it got to 9-3, because otherwise there would be a hung jury. So if you don't reach the required percentage, you'd have a hung jury. So you'd have no result. And if the parties wanted to continue on, they'd have to start a new trial and go that way. So often the judge wants the juries to deliberate. So it may have been the case here too. They were maybe perhaps it wasn't until the very end, after being instructed to go back and try again, that they reached a verdict that was sufficient, 75%. So I'm sure the ruling itself will be cited by Tesla counsel elsewhere, and we will see what'll happen. But I'm guessing most likely what will happen is the plaintiff also will file an appeal of this trial judgment because they have no downside. They lost. So they're seeking $400 million. They got zero. So the odds are that they don't have a big downside in filing an appeal. So they're likely to file an appeal. What happens after they file an appeal? An appeal might take a year to two, perhaps. And oftentimes parties file an appeal and then they negotiate something behind the appeal. Or perhaps there'll be some discussions or further settlement negotiations. Perhaps there'll be a non-disclosure agreement. We don't know. But I would expect there to be appeal. And so even though this is chapter one, I don't think it's final. I don't know necessarily that because I didn't attend the trial, I don't know if there's any necessary grounds by which the plaintiff would be able to reverse the decision, but I don't know. I'm not familiar with the record to make that conclusion. But they would have to basically show an appellate court a reversible error, not just like an error was made by the trial court or the trial court in the trial that was conducted before a jury, but for that error, the decision would have been different. So that's kind of generally enough to be a reversible error. So the result was good for Tesla. I'm sure it will be cited by Tesla in the future. It suggests good results in the future, but it's not binding, and it probably will be appealed. And I'll watch out to see what happens. Anyway, Hope that helps you. Hopes that clarifies the result and its impact. And have a great day. Be well. Take care.